So here's the big news: federal law that bans non-violent felons from owning firearms has just been struck down again, following a recent 8-1 ruling by the Supreme Court, which issued a GVR on the case. What's even more significant, the Attorney General's office has officially decided not to challenge that pro-Second Amendment decision. They're not bringing it back in front of the Supreme Court. Instead, they're choosing to let it stand as is. This is a major shift, and we absolutely need to break it down. Like I said in the intro, this video focuses on a pivotal case for Second Amendment rights, specifically how it affects non-violent felons and their legal ability to possess or purchase firearms. The Trump administration, along with the Department of Justice, has made the call to let the Range v. Garland decision, originally handed down by a 3-judge panel in the Third Circuit, stand without appeal. That means they are no longer seeking a review by the Supreme Court. So what does this mean in practice? It means that the Third Circuit's decision, which declared the federal ban on gun ownership by non-violent felons to be unconstitutional, at least as it applies to Mr. Range, is now the final word in that circuit. And that is a huge victory for gun rights. This ruling opens the door for others in similar situations to follow the same path Mr. Range took, filing suit against the federal government to have their Second Amendment rights restored. Even more encouraging is that, alongside this case, the current administration recently released a proposed rule change. If adopted, it would allow individuals who are federally prohibited from owning guns to begin the process of restoring their rights, a process that has been effectively shut down since back in 1992. Together, these two developments, the Range v. Garland case being left unchallenged at the Supreme Court, and the proposed regulatory changes, signal a major shift in the legal landscape. It's going to reshape the future of how Second Amendment rights can be reclaimed by those who were previously barred, especially those with non-violent convictions. We're watching history unfold here, and if you care about gun rights, especially restoration for law-abiding individuals who've served their time and stayed clean, this is a big win worth celebrating. For those of you who may not be familiar with it, the Range case centers on the issue of whether a person can lose their Second Amendment rights for life due to a non-violent offense under federal law. Roughly 26 years ago, Brian Range was convicted for misrepresenting his income to qualify for additional food stamp benefits for his family. To put it plainly, he made a false statement on a federal application to receive aid. That resulted in a Class A misdemeanor conviction. But because that specific charge carried a potential sentence of more than 1 year behind bars, it triggered a lifetime federal firearms prohibition under Title 18, Section 922, subsection G, paragraph 1. Because of this, Mr. Range decided to sue the federal government in an effort to have his gun rights restored. His case eventually made it to the United States Court of Appeals for the Third Circuit. Initially, a 3-judge panel reviewed the case and, relying on so-called historical tradition, concluded that only law-abiding, responsible citizens fall under the protections of the Second Amendment. They essentially said that Mr. Range no longer counted as the people protected by the Constitution. But the case didn't stop there. It was then heard by the full-bench en banc of the Third Circuit, which reversed the panel's decision. That full court ruled that Section 922G1 was unconstitutional as it applied to Mr. Range. The Biden administration wasn't satisfied with that outcome and asked the Supreme Court to intervene. However, after the court's 8-1 ruling in the Rahimi case, the justices issued what's called a GVR, granted, vacated, and remanded, which sent Range back to the Third Circuit for reconsideration in light of Rahimi. After reviewing the case again, the same Third Circuit panel reaffirmed its original position. In their ruling, they sided with Mr. Range, stating that despite his past conviction for a false statement, he still falls within the category of people protected by the Second Amendment. They further ruled that the government failed to demonstrate through historical evidence that disarming someone like Mr. Range aligned with the country's traditional approach to firearm regulation. One of the most powerful points in their opinion was a rejection of the idea that lawmakers should have unchecked authority to decide who counts as the people under the Second Amendment. They argued that allowing Congress to make that decision based on labels would effectively hand them the power to rewrite the Second Amendment by policy preference, something the Heller decision clearly warned against. That updated ruling from the Third Circuit was issued in December. At that point, the Biden administration was still in office and had taken the case up to the Supreme Court. But after the change in leadership, Pam Bondi, under the Trump administration, was the one overseeing the case. Her team requested a deadline extension to decide how to proceed, which pushed the decision date to April 22nd. That deadline has now passed, and they did not file a petition. What that likely means is that Bondi's office, possibly with input from the new Second Amendment task force, chose to let the Range ruling stand rather than pursue further litigation. I also suspect that the Department of Justice's recently released interim final rule regarding the restoration of firearms rights played a role in that decision. Letting the Range precedent remain in effect within the Third Circuit appears to be a deliberate choice. The Department of Justice has just implemented a new interim rule that eliminates the delegation of authority previously given to the Bureau of Alcohol, Tobacco, Firearms, and Explosives to handle applications for federal firearms rights restoration. According to the announcement accompanying the rule, this change is aimed at removing outdated procedures as part of a broader initiative under President Trump's executive order focused on defending Second Amendment liberties. With this temporary rule now in effect, the Department of Justice will begin allowing individuals who are not considered a danger to public safety to formally petition for their gun rights to be reinstated. Since the year 1992, Congress had prohibited the Bureau of Alcohol, Tobacco, Firearms, and Explosives from using allocated funds to process those petitions, effectively rendering the statute useless. But this new change revives that long-dormant process, finally making it functional again at the federal level. Under this updated rule, the Bureau of Alcohol, Tobacco, Firearms, and Explosives will no longer have a role in handling relief from disabilities applications. Instead, the Department of Justice will directly take over and evaluate each petition for restoration of gun rights. And the most important part, this change took effect immediately. While there will still be a public comment period before a final version is adopted, the interim rule is already active, and some applicants have already started using the new process. Taken together, this marks a major policy shift inside the Attorney General's office and the Department of Justice with regard to non-violent felons and their access to firearms. The government's decision to step away from the Range v. Garland case, letting the Ing-Bank Third Circuit ruling stand, is significant. Combined with this new DOJ-led process for restoring rights, it gives individuals two real pathways toward regaining their Second Amendment protections. To be clear, the Range case is an as-applied constitutional challenge. Right now, that ruling technically only applies to Mr. Range himself. However, because it is now controlling precedent in the Third Circuit, others within that jurisdiction can file their own lawsuits referencing Range to challenge their firearms prohibitions on similar grounds. In fact, we've already seen a few federal courts in other regions treating the Range ruling as persuasive authority, even though it's not yet binding outside the Third Circuit. Now that the DOJ has indicated it will no longer fight the range decision, this is an ideal moment for other jurisdictions to take up similar cases. Individuals who were previously stripped of their rights due to non-violent convictions may now consider challenging those restrictions under the same legal reasoning. On top of that, the new DOJ rule offers an administrative avenue to regain those rights without going through the courts at all. Overall, this is very promising news coming out of the current administration. The newly formed Second Amendment Task Force appears to be making swift progress in addressing long-standing legal issues, closing out problematic cases, and giving lawful citizens renewed access to their rights. Now we'll just have to wait and see what happens next. There's always a possibility, however unlikely, that something behind the scenes could change, like a last-minute petition or a quiet extension granted by the Supreme Court. But as of now, nothing new has hit the docket either yesterday or today. If anything changes, I'll keep you guys updated. If you found this video helpful and you want to support the channel, the best way to do that is by liking the video, dropping a comment, and subscribing. All of those actions help boost us in the algorithm and show YouTube that this kind of Second Amendment coverage matters. As always, thank you for watching. Don't forget to like, comment, and subscribe. And remember, this nation was built by scholars, and it will be preserved by armed scholars.